You understood the declaratory orders. There's only one qualification. What is the qualification? That no. The labor court has the power to grant declaratory orders, like the High Court. But unlike the High Court, there's a qualification in terms which limits. When you read that, you find that all the powers given to the labor court usually is limited to a point. What's the limitation? In the High Court, a High Court declaration can be done by the judge without any qualification, so long as the elements have been proven. What's the qualification? First, when can you grant declaratory orders? First. Did you read the notes? Okay, refresh your memories if you have the notes. The law regarding declaratory orders is not different from the High Court because they are all common law and then grounds. When can a court grant a declaratory order? What's the first most thing that the applicant must prove? Don't tell me you understood the notes. What the critical, crucial, foremost thing that the applicant must prove? Yes? Yes?
You say that at the High Court.
No. High Court, Labor Court. What's the... Before we go to the qualification, limitation, what must the applicant prove?
Is it not that it is an award?
No.
That was given by...
No.
Okay.
We are talking about declaratory order. Okay, let's go to it. No. No, those are on what subject matter it can. Labor court may grant greater orders in respect of any provision of the Labor Act, collective agreement, contract of employment, or wage order, so long as the declaratory order is the only relief sought. What must the person prove? 1, 2, 3, and 4 are things in respect of which it can grant a declaratory order. That's why you must read it. In respect of any provision of the Act, in respect of collective agreement, in respect of a contract of employment, or a wage order. So the Labor Court can grant declaratory order in respect of these matters. But what must the applicant prove? The applicant comes, he or she wants declaratory order in respect of collective agreement. What must he prove first? The crucial thing he must prove first. You don't just come to court and declare that this. You must have, why do you come to court?
I believe the applicant should have a right to make such a claim.
You are nearer? Very near.
But still far.
Well, yeah. Are you familiar with the High Court Act? You've read it? I didn't tell you because I thought you have done it before when you were doing, you have done interdicts and all that.
Yes.
Yes. You didn't do As the gentleman says, first thing he must prove is a right. You must have a right. The right may be immediate, it may be in the future, or contingent. It is in section 6, section 16 of the High Court Act. Mind you, the Labor Court is a division of the High Court. So it has all the powers of the High Court if it has not been limited by the Labor Act. So he must have a right. And we have given a case there, so if you read the case, you will learn. He must have a right. The right must be immediate, that you have an immediate right. Or it must be a right that you will have in future. Or the right may be contingent. Contingent means that you strongly believe you have that right, and you put sufficient evidence before the court. On that, let me ask you a question. Can someone come to labor court, someone who has been dismissed for any misconduct? Can he come to labor court and ask the court to declare that his dismissal is unfair? And that he must be put back to his post? Write the answer down and show it to your colleague. A judge should like writing, not talking, writing. You don't talk much. You are a magistrate, you know, you don't talk much in court. You do all your talking in writing. An employee brings an application for the court to declare that his dismissal is unfair. And so the court should declare it unfair and order the employer to put him back on his post within 2 days. They are usually very, very adventurous. Can the court, is it within the act? Can the court make such a declaration? Can you look at paragraph 3 of the notes? As I said, the power of the court, of the High Court to grant declaratory orders in section 16 of the High Court Act. The critical factor to take into account is that the power to the court is limited to a question concerning a right. Therefore, the court ought to inquire into the nature and scope of the right, and in the absence of proof of such right existing, or at least a contention that there is such a right. That's the meaning of future or contingent. The court has no jurisdiction. So what right would the applicant have? That he can never be dismissed? He can be dismissed. Dismissal is still part of our law. Yes?
While dismissal is still part of our law, the applicant in labor matters have got the right to fair administration.
Yes, you have a right to fair and substantive and procedural fairness to be dismissed. But you cannot be dismissed. You have no right not to be dismissed.
Shouldn't it be that you have the right to be fairly dismissed?
Yes. But you have no right not to be dismissed. He has dismissed you. Fairly and unfairly, he has dismissed you. Unless your contract of employment shows that you can never be dismissed. Even if you beat up the managing director, then you have a right not to be dismissed. Therefore, a dismissal should be done fairly, doesn't mean they don't have a right to dismiss you. He has. So he must do it procedurally. You are lawyers, you should don't look like an ordinary person. The fact that you have a right, you have no employee has a right not to be dismissed. If you have that right, then fairness does not even come in, isn't it? Yes. If you have a right not to be dismissed, fairness and do not come in. Because you have a right not to be dismissed. It doesn't matter what you have done. Beat up the managing director, steal all the funds in the funds. You cannot be dismissed. Okay. Read the three is the key factor. You must put that you have a right. The right may be future, it may be existing right. Let's say in terms of the contract of employment, you have a right to a motor vehicle of a particular make, then you have a right. If it's not given to you, you come to court for a declaration. What is the qualification? The High Court, the right is absolute. The power of the court to grant, the High Court to grant, is absolute, not labor court. What is the qualification? The qualification is that it should be the only relief you are seeking. That's the qualification, the only relief. In the High Court, we can grant declaratory orders, whether they are other relief you have sought, you can still grant it. The court can still grant it. For labor court, it should be the only relief. Let's say he applies that he is entitled to a vehicle, declare that he must be given a vehicle. Then you said, also, they must give me a driver. And I want a driver with a matric certificate. You are asking for more relief. It might be the only relief you are seeking. Okay. You say you are doing the urgent relief. The labor court may grant, you can see there also urgent relief. The High Court grants urgent relief in any matter and to any level. Unlimited. What's the qualification in terms of the labor court? Don't go and say, I'm a High Court judge, so I can do everything. You are sitting as a labor court judge, not a High Court judge. What is the qualification? Have you got the act? Those who have got the act, let me read what it says. (117), those who have it. 117E. This one act which you must sharpen your knowledge of interpretation of statute. Otherwise, you make a mistake every day. It has been drafted in such a way that it needs a bit of interpretation. Let me read it. The labor court has exclusive jurisdiction to, that is E, to grant urgent relief, including an urgent interdict. It doesn't put a full stop there. If you put a full stop, then it will be like the High Court. To grant urgent relief, including an urgent interdict, pending resolution of a dispute in terms of Chapter 8. If you miss the last part, you'll be making wrong judgments every day. It's not that you can grant urgent relief. The High Court can grant urgent relief. Full stop. Labor court to grant urgent relief, including an urgent interdict. They can grant urgent interdict. Pending resolution of a dispute in terms of Chapter 8. What it means is that there must be, Chapter 8 has what we call Part A disputes, Part B disputes, and then Part C disputes. You see, pending resolution of dispute in terms of Chapter 8. Chapter 8 is where you report it to the Labor Commissioner. He appoints an arbitrator. He reconciliates first before he arbitrates. What does it simply mean? What does the qualification simply means? Yes? It can grant urgent relief, including, so it means all urgent, or any urgent relief. Urgent declaratory relief, any urgent relief, including interdict. Pending the resolution of a dispute in terms of Chapter 8. What's the meaning of the qualification? Yes? Yes, there must be a dispute reported Labor Commissioner. People think that when you are an employee and you are dismissed, there's a dispute. There's no dispute. You may be very happy you have been dismissed. There's no dispute. Unless you have put dispute the Labor Commissioner. Counsel will argue in court, he has been dismissed, so there's a dispute there. You tell counsel, probably he's happy he has been dismissed. He doesn't actually like the job. So there must be a dispute, and must be Chapter 8 dispute. If you go to Chapter 8 disputes are there's a dispute affecting the national interest, Part A. Dispute, conciliation of disputes, that is conciliation of disputes, and arbitration disputes, Part C. So if there's nothing, for instance, if a permanent secretary's contract is about to end, he doesn't want to go home. He comes to court on urgent basis that his contract should not be cut. There's no dispute. He's unhappy about the letter he received. That means there's a dispute. In terms of it must be one of these disputes. It must have been, you see, it's pending resolution. The dispute should be pending resolution in terms of the act. It's only when you report Labor Commissioner that is pending resolution. And that's why nobody who has been dismissed, contract has been cut. Nkonga is the best example. If you read the judgment, there must be a dispute. At the labor court will be swarmed. If I was the judge, I was going to ask him, what does he think, the lawyer, his counsel, what makes me think that he's more an employee than a laborer? They are your employees. No laborer comes to court and say, well, they shouldn't dismiss me. you're not a greater employee in terms of the act, because the position you hold. You're an employee, you're an employee. You count that the Labor Act. Okay, any questions? So for interdict, that's the only qualification. There must be a dispute pending resolution. It doesn't just say there must be a dispute. It should be pending resolution. And it can only be resolution in terms of the act. For instance, if the employer, the case is Midco, I think it's in, I've put it here. You saw it. Midco, yeah. Where an employer rushes to court because the employees are going on a strike, and it's not in compliance with the act. What do you call a strike which is not conforming with the act? What do you call it? A strike which is not in conformity with the act. What's the street name? Hmm? No, that's not the street name. I mean the pedestrian name, wildcat strike. If you hear wildcat, that's what it means. Wildcat strike means it's a pedestrian term for illegal strike. Strike which is not in conformity with the act. So then the employer rushes to court because the employees they do very good job, and it will collapse his business. You cannot grant an urgent relief to stop the strike. There must be a dispute. And it's part A dispute, it's a dispute of interest. First thing he must do was to have reported to Labor Commissioner that they are going on a strike which is not in conformity with the act. The Labor Commissioner will establish conciliation. So it must be dispute, not just a dispute reported, it must be pending resolution. They might have a good reason for looking for an interdict, because the whole business is going to close. Look at Midco. All the carcasses are probably going to be destroyed, but that's not the law.
So even in such a case, you cannot bring an urgent application, even though you didn't go with the Labor Commissioner.
Because there's no dispute.
But in that case, with the carcasses,
yes, you have a good reason. You have a good reason, but there's no dispute pending resolution.
So whatever the case may be, must go through that. It
must be a dispute which has been reported and is pending resolution. And it must be a Part A dispute, Part B dispute, Part C dispute. I'm surprised an experienced criminal judge, magistrate is worried about what happens to the Midco. That's their business. There must be a dispute pending resolution. No matter how you sympathize with them. Probably you get all your meat from Midco, so you are sympathizing with them. Okay, that's the only qualification. There must be a dispute pending. You can see none of the applications have succeeded in the court. Those PSs and others who rush to the managing directors, who rush to the court because they. If I never sat on anyone, I was going to ask the counsel, what makes him think? What makes him think he's more an employee than any employee? If they all rushed, look at all employees in the country. They all rushed when they have been dismissed. It's a practical thing also. If every employee rushed who has been dismissed and doesn't want to report to Labor Commissioner, and they all rush to the Labor Court. So far as a PS main director, it matters not. Okay, good. Anything again? In terms of section 89, those who have got the act, I think it's 87. Okay, 87, those who have the act. I'm doing effect of arbitration awards. The labor court has the power to enforce an arbitration agreement. The court should hear, let me, 117. Yeah, to grant an order to enforce an arbitration agreement. What does it mean? What does it mean? What does the power mean? Louder. Oh, sorry. Okay. The labor. 117F. We are in 117F. 117.1F. The labor court has exclusive jurisdiction to grant an order to enforce an arbitration agreement. Because Article 87 obviates going to the High Court to make an award and an order of court. 87 says arbitration award made in terms of this part is binding unless the award is advisory. So they don't need to come to court to make an arbitration award and award of the court. B is binding unless the award that becomes an order of the labor court on filing the award in the court. By merely filing, it becomes an award of the court. So after an arbitration award has been granted, there's no need to apply to the court so long as the award was made in terms of the act. Okay, I'll come to that. I just want to prove that you are wrong, then I'll come to that. Any party affected by the award or the labor commissioner. So any party who is affected by the award can merely filing it with the registrar becomes an order of the court. Or for this act, you have to apply to the court for the court to make an order of court. But it was too much for employees. It doesn't say, that's why you have to read an act carefully. The words, we usually say that in interpretation, there's a presumption that the legislature does not use words unnecessarily and without meaning. It doesn't say an award. It says grant an order to enforce an arbitration agreement. Arbitration award is not an agreement. Huh? Is it an agreement? Arbitration award is not an agreement. It's an award. And don't tell me award is equal to agreement. It's not. What does it mean? What we are forgetting is that arbitration is a tribunal. It exists in the country, whether this act came in or not. And two parties, employer, employee, can decide to go for private arbitration. Yeah, that's what it is for. It covers it. Not every arbitration must be done in terms of the act, if it's about employment. The employer can decide. They don't want to report to the labor commissioner for him to resolve it. They want private arbitration. And they appoint a private arbitrator. But an arbitration is not lawful, enforceable, unless there's an agreement. So whenever such a thing happens, you come to court for the court to enforce that agreement. If you read some contracts, It will say if there's a dispute, you should go to arbitration. If it's about employment, that's the kind of arbitration. It's a private arbitration. So one of them should come to court to enforce the arbitration.
Sorry, Justice.
Yes.
When the Act says that an arbitration award made in terms of
That's 87, yes? Yes.
1A is binding unless the award is advisory.
Yes. Okay.
Advisory.
Okay. Yeah. You find that in you find that the arbitration is just advisory. The arbitrator should just advise, not to make a final determination. It's very rare. It means that arbitration is a private arbitration. It's not in terms of the act.
So we can still go to the High Court after that?
Yeah, then to not labor court, to be the High Court. But since about employment,
If that dispute is about what, then I can...
you can come to labor. Yeah, you can come to labor court.
If it is
You can only come to labor court to enforce that agreement. But after the award has been made, if you want the award to be made an order of court, then you must go to the High Court, not the labor court.
if you want the award for private arbitration,
Yes? Yeah. Because if you 87, arbitration award made in terms of this part is binding unless it is advisory. And B, becomes an order of the labor court on filing the award in the court by any party. Because if it was an arbitration carried out in terms of the act, you don't need, one party does not need to take any further step like bringing an application by some legal practitioner, getting money for nothing, just to tell the court to make an award of the court. By just merely filing, a messenger files it, is stamped by the registrar, it's an order of the court. If it's private arbitration, labor court does not deal with private arbitration. Let me put it simply. What it means that if the arbitration award is made in terms of the act, it's automatically an order of the court. So long as just after merely filing it, and there's the registrar stamp, there's a revenue stamp, it's an order of the court. It can be executed. Any more questions? I think that's the end. Then there are general matters. Those who have the act. Is from the labor court can determine any other matter which it is empowered to hear and determine in terms of this act. We have mentioned so many. This is just an omnibus clause to make sure that nothing has been left out. You must be careful about the interdict because it creates a lot of problems in the court. People rushing to get an interdict. There must be a dispute pending. Yes.
The issue of agents.
But I'm doing all this. I've not gone to principle of agency because I thought you've done this already. And you know Salt and Smith. You have done agency already?
Under the...
Yes, yeah, general, yes, you have done it already. You know Salt and Smith, a case? That's a case, even if you are sleeping and somebody wakes you up and say agency, you must mention Smith and Salt. Yeah, just mention it. Immediately you wake up, Salt and Smith. Because that is the basis. Okay, that's why I've not gone into the law of it. Because even if it's not the High Court, you don't just get agency by merely asking for it. You don't even get it. Doesn't matter. You must prove that it is urgent. Why? The reason is that it will be unfair. There's a long queue of people waiting. For your case registered is 850. The court is hearing only number 10. You want to go to number 11. Are you not taking somebody's right under the Constitution from him or her? So don't talk about it's not fair. It's a long queue. We are in a queue. You want to breach the queue and come forward. Ask the deputy registrar how many applications we get a day. So if there are 850 applications pending in the High Court, you just rush there and say, mine is 850, but hear it. But the court is hearing number 12, number 11. So no, put mine there. Why? You must give a very good reason why you want to join, why you think you are so important that everybody should stand aside and you should come in. I have a very good reason. So there's nothing unfair about it. So when it comes to labor, apart from the proving that it's urgent, you must also prove that it's a dispute pending resolution. That's what that it says. There's no right which is absolute. There are qualifications. You can vote by register first. You can't go there and say, I want elections. Just go to the, I want to vote. Oh, but where's your card? Why should I have a card? I'm the chief in this committee. All these are my, even you are one of my subjects. You must register first. Is your right to vote being taken away from you? No. Okay. Any question? No. So there's nothing unfair about it. All that is a proof that you have an agent. Even when it's not the High Court, if it's a High Court, you don't just get your matter heard on urgent basis without even serving the papers, unless you prove that it's urgent. At times, you don't, in the High Court, you don't even to file papers. Your matter can be heard. I've heard a case where there were no papers filed. Why? It was so urgent that to file papers would defeat the very purpose of the agency. This is about blood transfusion. So counsel just came to court. There was no brown sheet. There was no brown file. They just came to the court, filed one sheet of paper that they should put the matter down for hearing. As we sat, there were no papers filed. So the counsel had to put witnesses to be heard orally. That's urgency. But you must prove that why you have not even filed any papers. Yes? So that is it. You must. If you are from MIDCO, you're managing director of MIDCO. Let's say you leave the law, you want to manage director of MIDCO. You don't say, but the animals carcasses are getting rotten. So let's rush to this judge, and he gives us a application. You cannot do that. You must have there must be pending dispute. There's no rule of law that every labor should be reported to labor commissioner. You can resolve it amicably, isn't it? Yes. The employer wants to dismiss you for misconduct. He calls you in his room. So actually, I don't like this job. I'm leaving. So long as you give me 2,000, 3,000, I'm happy with it. I'm going back to my village. 3,000 in the village, I'm a king. So I'm going. So not every. Except that then you lose certain rights. Certain protection, you lose certain protection. Actually, not all labor disputes, people resolve them amicably. Especially in the big businesses, they can set up a private arbitration. That's if you want protection of the act. Any more questions? As you know, the Labor Act is more for people who cannot protect themselves. You remember Judge Hannes' case, where he was thrown out, that he was not an employee. Yeah. He was working in the state. It was an employment dispute, but he did not come under the Labor Act. So not every person who works comes under the Labor Act. Judges don't come under the Labor Act. Okay. Any more questions? So you are ready to sit as labor court judges? Not yet. When? You can see I've given, those cases I've given are very key cases. They deal with almost all the issues that you may bring. Of course, in laws, the magistrate, you know very well, every day there's a new thing. But basically, the cases I've given are the usual cases, maybe more. And if you're a judge, if one case solves your problem, don't go and read 20 cases. I've done a case where there were 50 authorities. 50, not 50 authorities. I only read 5, and it solved my problem. The case I held that being chief magistrate, chief lower court is not a magistrate. There were about 50 cases because there were very, very senior counsel involved. So if one will give you, don't go through all cases. They do that in the High Court. In the Supreme Court, you must prove why. You must tell the court why you are citing more than one case for a particular principle. High Court people, the same principle they cite, so probably to impress the client who is sitting behind. This versus this versus that, and that case, going from place to place, from India to South Africa and back, America and back. Supreme Court, you must give a reason why you are citing more than one case to prove a particular principle of law. We don't have that in the High Court. So like the Mitko case solves our problem. Okay, so we finished labor. Is there anything you wish to ask? This is not a law school lecture room. Anything you want to ask? Like if you are appointed, what do you expect in the labor court and all that? In most cases, there are no, many employees don't have lawyers. Many employees. And for the labor court, it must be a practicing legal practitioner admitted, authorized to practice, who can appear for another person, for the labor court. You don't just bring your uncle because he read law for 1 year in Wits University. We do that in the arbitration, in internal disciplinary, but labor, it must be legal practitioner. He can represent himself, of course. He himself can represent himself. Okay. Anything you wish to know? Yes? Don't just sit and then when you are appointed, you the first case, oh, I wish I had asked the judge. That's the very problem he was talking about. Eh? You will call, yes. That there's a problem here. Okay. So can we go to costs? We go to court. If we can still go, but it doesn't matter. Is there any one of you who does civil? A magistrate who does civil? You're criminal magistrate. Okay. Because there's no civil in criminal, isn't it? There's no cost in criminal. I understand, yeah. The basic rule is that costs are awarded to a successful party. What they say, cost follows the event. I'll give you, I've got some notes also. Let me read the first, just listen carefully. Costs are awarded to a successful party in order to indemnify him or her for the expense to which he has been put, by either being compelled to institute proceedings or compelled to defend proceedings. That's all that cost means. And its costs, never put first, just cost. They don't mean the same. Cost of something is what you pay when you purchase an item. Costs. So it's a cost order. Cost order. Okay? And usually you don't get everything that you have spent because of taxation. If the two parties don't agree about the cost that one person has brought about, you go for taxation. Have you heard it before? No, apart from the deputy registrar. You've heard it before, isn't it? So there's taxation. So the successful party has prepared bill of costs, sent to the other party to pay. If he disputes an item or disputes the magnitude of an item, then they go for taxation.
Is it only if the other person disputes?
Oh yes, if he's very happy with the why should he go for taxation? Taxation is a protection of the person to pay costs. Where then the taxing officer will go through item by item. For instance, you said, I wrote 10 letters. Why did you write 10 letters? I sent the messenger 10 times. Why did you send him 10 times? Because they charge all that. Okay, you are right or not. I am not familiar with the magistrate court. But what happens in the high court is that where costs are awarded, the party in whose favor the costs were awarded, counsel will prepare a bill of costs, sent to the other party. That party says, I'm happy with it. The high court doesn't hear it again. If he's not happy, then they go for taxation. And the taxing master will tax it. Probably it was about 10,000. He's not happy about it. Taxing master may bring it or even increase it. It's her discretion. Still, if after taxation a party is not happy with it, then the taxing master prepares a case for a judge in chambers to review it. Yes, that's what happens. In the court, I'm the only one in the judge who do it. Many judges don't do it. They think it's just too tedious. And then you allow that, I don't allow it. Okay. Anything, you have to understand that first, that little, can I read it again? Costs are awarded to a successful party in order to indemnify him or her for the expense to which he has been compelled to go through, either to initiate proceedings or to defend proceedings. And because of taxation, you will not get all your costs. And this is what we call party and party costs. It's the lowest. And I put a case there, you read the case. The general rule is that costs follow the event in the sense that success carries costs. When a plaintiff comes to court, he has been compelled to come to court. He has been successful, he must pay his cost. I've done a case where a leader who sued for defamation, was looking for 500,000. Namibian dollars, that's a lot of money. That's some small ministry's budget for the year. After the case, he was successful, and I gave only 60,000. There were reasons for it, why it came 60,000. Because the newspaper, the editor were looking for him to go through the article before it was published. But he wouldn't be bothered. So he didn't get 500,000. Apart from that, it was too much. He has been successful for the defamation. This is very important. Do you give him all his costs? Since I gave him only less than slightly less than 1/10 of what he asked for, has he been substantially successful? Think before you answer. It's a defamation. He wants 500,000. So no, it's too much. That's the budget for Ministry of Justice for the year. And also, when you are granting defamation damages, the law in the country is that you must look what has been done previously in other cases. If every judge, High Court, Supreme Court has given 10,000, 5,000, don't go and give 60,000. You have no reason for doing that. There must be a comparative analysis of previous orders. And you have a very good reason for not giving him the 500 he asked for. If the budget of your ministry, okay. Do you give him all? Because you must, if he has not been substantially successful, you don't give him all his costs. He must be substantial. The word is substantially successful. If the example I gave, the plaintiff wants $500,000 Namibian dollars. For good reason, he gets only 60, which is slightly more, 1/10 of what he asked for, 100th of what he asked for. Has he been substantially successful for him to get all his costs? Think before you. Can you write the answer and let me know? Show it to your friend. So that you all attempt. One thing a judge should not be lazy to do is writing. Writing. Not talking, writing. Has the plaintiff been substantially successful? Because that's one qualification. The other qualifications that plaintiff, the successful party doesn't get all his score. He has not been substantially successful. No, but he claimed that he has been defamed, and the court agrees with him. He had been substantially successful. He wouldn't have got anything if he didn't come to court. He came with a claim of defamation, the literal claim of defamation. And the court says, yes, you were defamed. He has been successful, substantially successful. The fact that he didn't get that amount of money is not the reason not to give him his costs.
Is it now all his costs?
Yes, all his costs. His costs. When immediately we say cost, the court doesn't even care how much you get. You understand what I mean? Then your lawyer will prepare bill of costs, go to taxing master.
But now
Because when he went to the lawyer and he put this claim, whether he got $500,000 or 10, you think the lawyer didn't do what he must do? He didn't put all the case before the court, didn't do all the research, didn't present to the court all the authorities, appeared in court. Did he appear in court only for 2 days just because he got only 60? He was in court throughout.
Shouldn't the award determine
Now,
the scale of
what determines is, has his claim been successful? And that's why it's not good to have so many claims. Let's say he claimed, I've done a case, another one, where there was claim 1, claim 2, claim 3, claim 4. These are different claims. You understand what I mean? So if only claim 1 becomes successful, of course you don't get all your costs. I'll give you the 30%.
Judge, I'm thinking of the situation where, for example, ask for 1.5.
But you're talking only about defamation.
Yes.
Okay, very good. Okay, okay. No, I understand. Yes. You know, you argue there's no correct answer in law. So long as you can support what you have said reasonably. There's no correct answer in court. In law. So long as you can reason. The law school I went to, when you do an exam, the lecturer must give marks for everything you do. He doesn't just read 5 pages and say 20%, 10%. How did he reach there? Probably he was sleeping and he just wrote it. Or he was angry with his wife and just wrote it. So you must, because the reason is that you have said something. You know, everything you do correctly, you are given a mark, and then he totals. Not that you read 10 pages, a lecturer, then you just put 10%, 60%. Where did you get there? No, the law school attended, actually it was a rule, it's a rule that you are marking my first degree. If you are marking, you must give marks. If it's an essay, you give marks. If it's a scenario, you give marks. Because he can't be wrong everywhere. Okay, so, no, that's a good, but he came to court to vindicate his right to dignity. And he has been successful, isn't it? And I don't think the lawyer does less work because the claim is for 1 million or 20,000. He must still prove intellectual elements of defamation. Where you can reduce where the claims are. He makes about 5 claims. And then he was successful only 2 claims. That, of course, because they are different claims. So that is one qualification. The court may also depart from this general, because you remember we are dealing with only party and party costs. Can depart from the general rule that cause follow the event. If the special circumstances exist. What are special circumstances? And I've given a case, you read the cases. Let me read number 2. The successful party may be deprived of his or her costs. Even at times, the successful doesn't get his costs. At times, he doesn't get anything. The third party may be deprived of his or her cost where that party has acted vexatiously or frivolously in instituting proceedings or defending proceedings. Vexatiously and frivolously in the legal sense is when that party's case is obviously unsustainable. As you can see that one, it was sustainable. He was vindicating his right to dignity. So it was sustainable, and the court has agreed with him. manifestly groundless, or utterly hopeless and without foundation. That's when you can decide not to give him any cost. I've done cases where I don't give ground cost to anybody. And obviously, no, I've got notes here, you don't need to, I'll give you this. Unsustainable, manifestly groundless, or utterly hopeless and without foundation. Okay, so good. It's obviously unsustainable. Let me start from frivolously in the legal sense. Is when that party's case is obviously unsustainable, manifestly groundless, or utterly hopeless and without foundation. Particularly where somebody is suing on derelict, but his lawyer does not understand the elements of the delictual claim at all. He doesn't understand. When his lecturer was teaching, that time he was not in court. He was not in the classroom, and he never bothered to read. And he takes the case on. He has no basic knowledge of the elements of the derelict. And he puts papers, groundless. For instance, insult is not defamation. Insult is not defamation. Someone say you're a fool, it's not defamation. No, it's an insult. So it's groundless. The contract, he doesn't understand the elements of contract. And then, for instance, if he sues on contract, and he doesn't know the elements of contract, so you don't get anything. And when you force someone to come to court, the plaintiff forces some defendant to defend a matter, you may not get your cost either. In what circumstances can such a thing happen? Under what circumstances can you think of? Where the defendant has been dragged to court reluctantly. Let's say he owes you 100,000, and he says, I will pay you in 3 months' time. I'll pay 3 months' time. You come to court. In court, the case takes about 6 months. The judge is going to take 3 months for his judgment. That is 9 months. But you too, I will pay within 3 months. If you're successful, the court will not grant any cost. And in court, there's proof that he had the money to pay you within 3 months. But you say, no, we'll go to court. You want the court to decide. Some people like going to court. And the case takes about 3 months for the hearing, 3 months for judgment, 6 months. What have you gained for coming to court? You don't get, you just come to waste the court's time. So that's where you don't get your cost. And you see, in most constitutional matters, it's just a convention in the court. Depending upon the social status, the economic status of the person. Usually, the Attorney General's chambers don't even ask for costs. Particularly if it is the first time that particular right, in terms of the Constitution, is being decided by the High Court. It means actually the person is doing us a favor for making a developed jurisprudence in that area of the law. We usually don't grant costs against an individual. Most constitutional cases, the court very rarely grant costs, and the Attorney General does not insist, particularly if it's about an area of Chapter 3, which is not commonly heard in the court. It gives the court opportunity to develop the jurisprudence on it. They may not insist on cost. If it's what? You understand legal aid? I understand it. If someone is under legal aid, he doesn't pay costs. Yeah, I understand, yes. If the person is legally aided by the Directorate of Legal Aid, Ministry of Justice, if he loses, he doesn't pay costs, I understand. It's a rule, it's just a convention. Yeah, that one I was talking is page 14. When you get there, the successful party may be awarded only a part of his or her costs, where he or she has not been successful on all claims. E.g., where plaintiff seeks judgment for a multiplicity of claims, claim 1, claim 2, claim 3, and the plaintiff successfully succeeded in claim 1 and claim 3, and the defendant successfully challenged claim 3. Then you don't get all your costs. I've done a case also where that's the vexatious and frivolous. It was a contractor and a lady. The lady was a defendant, and he did work for the contractor, for the lady, and there were problems about the quality of the work and the payment. So this lady was asking the person, this has not been done, come and do it again. He refuses. At times, he goes there, the lady is not there. They put that, I told to give me at least 2 days notice before you come. So it became a tussle. He said, no, but let's find somebody to settle this for us. They live in a whole neighborhood. The statement of the contractor was that we shall see who is rich. We will go to court. He was successful. I gave him nothing for his costs. He had a wrong motive for coming to court. He didn't come to court to vindicate a right. He came to court to show the lady that he is rich. He was successful. I gave him nothing. He didn't get his costs. And I gave a reason that he didn't come to court to vindicate a right. He came to court with an ulterior motive. Okay, good. So those are party and party costs. Those are the cheapest. It's not much. When it comes to client and attorney costs, those are very high. What it means is that you pay the costs. It means the party and party cost is within the attorney and client cost. What means that you pay every expense that the successful party has spent. Every expense. Attorney client. Actually, I rarely grant it, very, very rarely, because it's very high. Most of the cases I do, all senior counsel appear. And if you grant attorney-client cost, it's high. There must be a very good reason. One thing you must not let any legal practitioner persuade you is that, especially where the person is representing himself or herself, he may not have any case at all. So no, he has wasted the time of the court. I tell counsel the fact that he has been misadvised, especially if he's represented even by counsel, it doesn't mean that he didn't have a good motive to come to court. He may be misadvised. He may not have any case at all. It's not being vexatious or frivolous, but he thought he had a strong case. Especially when he has legal practitioner with him. So you have to be very careful not just because the case is completely hopeless. He shouldn't have come to court at all. If he has legal practitioner with him, and he says, we'll go to court, he comes to court. Party and party costs are very, very high. I'm going to read something to you, a South African case. An issue is done to mark the court's disapproval of behavior of a party or his legal practitioner. Actually, that is when. To mark the disapproval of the court in respect of the behavior of the party for coming to court or for institute proceedings, or behavior of a legal practitioner. Papers are not put in properly. Discovery has not been done. Let me read a case which I did, which I was going to grant. I'm saying this story, I'm telling you this case for two reasons. When you can grant it, under what circumstances. Somebody, is Peter and Jacobs, a magistrate who was dismissed 5 years, 8 years, and then he brings an application to the High Court. When the application came, the legal practitioner, the government legal practitioners, informed his legal practitioners that there has been unreasonable delay, so he must withdraw the application. And quotes a Supreme Court case, Kaya and Chief of Defense Staff, the most incisive decision on delay in applications by the Supreme Court. So it means the law that because of Supreme Court's case, you must withdraw because the application is too old, 5 years. Kaya is about 12 months, 18 months. So the magistrates, the ex-magistrates, legal practitioner, brushes aside the advice from the government attorneys, still pursues the application. It's vexatious and frivolous. Vexatious. It's just annoying. This is a Supreme Court case. Even the High Court judge hearing the matter cannot do anything. And they have not, when there's an unreasonable delay, you must bring an application to condone the delay. The court should condone the delay first before you can hear the matter. There was no application for delay. They just put in the application, set it down for hearing. So in the judgment, I wrote that if they had asked for attorney and client costs, I would have granted it. Because it was vexatious. I didn't grant it because it was not sought. I don't usually grant attorney and client costs if it has not been claimed on the papers by the other party. I wouldn't do it more. The reason is that because it is higher, you must give the other party opportunity to be heard. So if you are considering granting such an order, tell the court, tell the council that you are going to consider it, and then they may have a good reason to persuade not to do that. So I wrote in the judgment that one, I was going to grant it if they had asked for it, considered it. But because they did not, even though the conduct is vexatious and frivolous, I didn't grant, I just granted party and party cost. This is a very good example where you can grant attorney-client cost. Where the other party says, because of this law, just withdraw the application. It's groundless, has no foundation. It won't start off because of care. Okay. I'm going to read to you a very good case from South Africa. I'll give you this. Clearly, I'll give you so you don't need to write. Clearly, there must be grounds for the exercise of the court's discretion to award costs on an attorney and client scale. Some of the factors which have been held to warrant such an order of costs are: 1, that unnecessary litigation shows total disregard for the opponent's rights. 2, the opponent has been put into unnecessary trouble and expense by the initiation of an abortive application. 3, that the application is foredoomed to failure since it is fatally defective. The application was just defective. Affidavits have not been filed, not commissioned. It means there's no evidence actually from the other side, if it's an application. Or that the litigant's conduct is objectionable, unreasonable, unjustifiable, or oppressive. So those are, I'll give you those. That's when you get, as I said, you have to be very careful granting it because it's very high. If you have got a senior counsel with an assistant, it's very high for the other party. You must have a very good reason. As I said, it's usually granted to mark the court's displeasure with conduct of a party or his legal practitioner. And if you are considering granting such an award, you must put to the other party for them to, so they are ahead. Give them order. If you grant cost and you don't put party and party or anything, if you just say cost, it is assumed to be party and party. You understand? If you just cost, party and party. Actually, we don't usually say party and party, we say costs. We put party and party if the other party has argued for it and you have denied it. Then you make sure that you put party and party because you are denying it. I'm going to, in our law, in our practice, you have two kinds of, before 95, as you all know, we had advocates and attorneys. The bifurcation of advocate, attorney is not, it's not statutory. You understand what I mean? It's not in any statute. It's just convention. It's not statutory. You have only legal practitioners. But the Act allows a legal practitioner to practice without Fidelity Fund certificate. What do you mean that such persons do not contact clients directly? If you do so, it's professional misconduct. The law allows that. So you have, that's why you hear advocates. You hear advocates. It's not statutory. They just call themselves advocates, and it's a wrong. People think that they are cleverer than anybody else. It's not true. Some people do their own cases. So Namibia does his own cases up to the Supreme Court. He doesn't instruct anyone. Is he worse off than someone who calls himself advocate? As Maris said, it's not the title which makes you brilliant in court, but what you do in court. Okay, so that's why we find that way. It's not there. Before 96, before the Act came into force in 95, it was there, attorneys and advocates. So now the term we have used is instructing counsel and instructed counsel. So you see, you read judgments, you see one instructed counsel, another instructed counsel. What it means is that X, who practices with Fidelity Fund certificate, instructed his colleague who practices without Fidelity Fund certificate. So he's instructing, that one is instructed. So after the case, he will argue that the cost should be cost of one instructing counsel and one instructed counsel. Listen carefully. Okay. You find that some of our legal practitioners have SC after their names, senior counsel. That was abolished in amendment to the Legal Practitioners Act. But the court has allowed the convention. As you all know, in law, if something is not banned, it means it can be done. They just amended the act, but they didn't say nobody should use the term. Okay. So there are people who have senior counsel. The convention is that in countries which this system is there, you don't appear alone. There must be a junior. So if you see Advocate Frank, he comes to court with a junior. Another advocate, somebody who practices with a Fidelity Fund certificate. It's a convention. You don't expect them to be in court. It's a convention. Law is, practice is conventions. Oh, okay. So we left where I said Advocate Frank. So we'll continue from Advocate Frank. Okay. Oh, okay.